Welcome back to Seminole Sidelines. We dive back into the Florida State ACC case. Monday was a, let's say, busier afternoon than morning in Judge John Cooper's court. We welcome in Osceola publisher Jerry Cutts, our legal expert Tallahassee lawyer Will Fixel. I'm Bob Ferranti, editor of the Osceola. So Will, we're going to let you jump right in here. One of the discussion topics was something that sent me to Google about what is ripeness. We'd like you to address what it is, why it was important for the overall concept of this case.
Sure. So thank you, Bob. Thank you, Jerry. It's great to be back with you. So ripeness is a concept in the law that just in plain terms means, is the case ready to be adjudicated? Is the case ready to go to court? And so in declaratory judgment actions, and we talked about what a declaratory judgment action was in the last podcast that we did, ripeness can often be an issue. In other words, you want to interpret a contract, but is it ready to be interpreted? So ripeness is that contract ready to be interpreted? The FSU obviously filed a complaint and alleged that certain breaches of that contract with the ACC had occurred, and that because of those breaches, that contract, certain damages provisions of the contract and other provisions of the contract were ready to be adjudicated by the court. Judge Cooper heard the ACC's argument that wasn't the case, that in effect FSU had to withdraw from the conference in order for the damages provisions for what it would mean financially if FSU did withdraw from the conference to be adjudicated before Judge Cooper. What Judge Cooper said is because the complaint itself at this early stage of the litigation alleged breach, alleged that the ACC had taken action to violate that contract, that it was ripe, it was time to determine whether certain damages provisions, what they meant. And, again, in a lot of these topics I think we're going to talk about today, Bob, are often theoretical. You talk about them in law school. They're not the most interesting topics in the world. But again, to give your audience a little broader view, where we are in this litigation is with their very initial stages. And so what's happened is that a complaint was filed, and not unusually, ACC said this isn't even a proper complaint. The words in the document weren't right. And one of those arguments was the words in the document don't indicate that this is even ready for decision before the court, because in effect, we don't need to we don't need the court to adjudicate anything with respect to damages because the parties are still in the contract itself. And what Judge Cooper ruled on this particular issue is, well, because FSU in the document, in the complaint, said that certain breaches had occurred, then this issue of is the exit fee appropriate? What does it mean that there's a grant of rights, and that FSU, if it leaves the conference, has already given its media rights to the ACC for another decade? Is that appropriate? That those are issues that he can decide.
Well, the other fundamental issue, and I know it's your favorite subject, is what kind of stalled the case, the hearing, and that was on personal jurisdiction. The ACC alleged that that there was Florida State's filing was not properly worded on personal jurisdiction. Can you talk a little bit about that subject? And I know it's like not your favorite topic, but.
Well, yeah, Jerry, and I described it to you yesterday as like watching paint dry. And, personal jurisdiction is frankly not an issue that lawyers deal with that often in practice, because typically there's a very low standard for personal jurisdiction. And first, let me just kind of describe what it is. But what personal jurisdiction is that we live in a federalist country, right? And what that means is that there are different levels of government. So there's the federal government, that's the entire country. And then there are, each state has a government as well, and it has jurisdiction judicially to adjudicate certain issues that affect each state. When you're trying to decide whether each state is affected or it has jurisdiction over a matter, you look at it from a couple of different ways. One way is personal jurisdiction, which is, does the state have jurisdiction over that individual? Okay, and as I said, it's a really low bar, and there's some complexity to it, but it boils down to, at its basic, has there been enough interaction between that individual and the state to allow that state to adjudicate a matter involving that individual? That's the basic idea. And so, an example of in which personal jurisdiction may not exist would be, well, what if there was a diner that was at the end of the Appalachian Trail in the New England area, in Vermont and New Hampshire, somewhere like that, and it served, was a small little diner that served hikers on the Appalachian Trail. Never did any business in Florida, but someone from Florida went and slipped and fell in that diner. And then they came back to Tallahassee, maybe there were or Florida, and there were some more complications from the case, and they had to sue a hospital in Florida who treated them poorly. And they sued everyone that was involved with whatever injury that individual suffered. The question would be, does that little diner have enough contact with the state of Florida to allow the state of Florida to adjudicate that issue that could affect that diner, that could make that diner pay damages? So in a case like that, that could be a legitimate issue. And the basic idea would be, is there minimum contact between that entity, the LLC, the diner, and the state of Florida to allow that diner to be dragged down to the state of Florida to have a case adjudicated in which it could have to pay damages. Obviously, the ACC case isn't that. The ACC is a major national corporation, so I think substantively, and I think it was alluded to at yesterday's hearing, I don't think there's a lot of argument substantively with respect that the ACC has engaged the state of Florida. Two of the member institutions are in the state of Florida. They play football games in the state of Florida. They sell merchandise in the state of Florida. They play all kinds of athletic events in the state of Florida. I suspect at the end of the day, substantively, there won't be much of an argument for the ACC that the state of Florida doesn't have personal jurisdiction over the ACC. Nevertheless, the ACC made the argument, well, even if that is true, under the pleading standards, under the standards in which you file a complaint in the state of Florida, you still have to allege that there's proper personal jurisdiction. You have to write in the document itself that there's personal jurisdiction. And so what happened in the ACC case is, frankly, a relatively minor error by FSU, and it appeared that they may or may not have alleged personal jurisdiction properly. And what Judge Cooper said is, given the gravity of this case, given the amount of money that's at stake, let's just make sure that it's done right. And so ACC, you're going to, at FSU, you're going to go back and I'm going to give you time to fix the problem, to rewrite the complaint, to make sure that personal jurisdiction is properly drafted and included in that complaint. And in particular, the very particular type of personal jurisdiction that FSU was alleging that the ACC is that allows the ACC to be sued in the state of Florida, and that would be one that involves certain minimal contacts related to commerce occurring in the state of Florida. So really, the upshot of this is just that FSU is going to have to rewrite their complaint to properly allege personal jurisdiction. My belief is that at the end of the day, given how much business the ACC does in the state of Florida, it will be form over substance, and that the ACC will, or the court will find that the ACC can be sued in the state of Florida. This is just Judge Cooper saying, let's make sure it's written right in the document itself. So FSU, you go take another bite at the apple and try again.
Well, let me follow up with a couple. Judge Cooper asked Florida State, how long do you think it'll take for you to do this? And Florida State responded 7 days. He turned to the ACC and asked them how long they would need to respond to it. And they said 20 days because they were concerned that there may be, in Florida State's writing, there may be things that they needed to analyze and be sure were okay. You think, is that sort of typical? And question one. And question two, it creates a delay of at least 27 days before they can get back into hearing it. What are your thoughts on that?
Yeah, so I think 7 days is pretty quick for FSU to file what's called another amended complaint. The case was dismissed without prejudice for FSU to refile. So FSU to refile the complaint. So FSU is going to fix the personal jurisdiction issue. It's such a minor issue that 7 days is pretty quick, but given how minor it is, that's not unexpected. FSU has a powerhouse law firm, Greenberg Traurig, that they're going to have a couple lawyers, fix the pleading issue, fix the document itself within. Probably it's already drafted, Jerry. To be honest with you, they probably called up an associate and said fix this, and it's fixed. The ACC asking for 20 days. So when you file an amended complaint like that, or a new complaint because they need to fix something that's just in the document itself, you typically get 20 days to respond to any complaint, to either move to dismiss, to answer, to file what's called a responsive pleading. Did the ACC really need that, given that this is really going to be a minimal change in the document itself? Probably not, but it appeared to me that the ACC, to steal a term from the ACC, was kind of playing the four corners offense. They're trying to slow things down. And that probably goes back to what we discussed in our last episode, where they may want to push things in North Carolina ahead of Florida to get that race to the judgment that we discussed in the last episode. And so I think that was while typical 20 days, I question whether the ACC really needs the 20 days, or they're just trying to stretch this out as long as possible as a litigation tactic. And there's nothing wrong with that as a litigation tactic, but substantively, I don't think they likely need 20 days.
Okay, well, again, to remind everyone, Judge John Cooper loves mediation. He brought it up a few weeks ago in court. He was a 10-year mediator. Conceptually, it gets a case to where both sides can sit down at the table and have a discussion. I think we've talked a good bit about this on the last show. There are some complexities here. We have a court case in Leon County. We have a court case in Mecklenburg County that you just addressed, Will. What is the judge ordering as far as these legal teams going back to their bosses, their constituents? And in the ACC's case, this is a lot of presidents and chancellors. How does this potentially unfold from a mediation standpoint?
Yeah, so Bob, you're correct. Judge Cooper said, I want the parties to sit down and mediate this case within 120 days. So let's start by just explaining what mediation is. So mediation is often court ordered. It doesn't have to be, but it is in effect a process by which the parties try to negotiate a resolution to the case outside the court system itself, outside litigating the issue in court and going to trial and going through appeals and going through motions practice and doing everything you've got to do to litigate the case. You're 100% correct. Judge Cooper was very clear that he wants the parties to mediate. He said he's seen a lot of cases settle early in the litigation, in part because attorney's fees at that point have not accrued to the extent that they will later in the litigation. All of that is 100% true. What your listeners need to understand, though, is, and I think we were talking earlier, we may talk about this on a future episode, this is going to be an exceedingly difficult case to mediate, given, as we discussed on the last episode, how many parties have seats at the table. Like I said, I hope we can talk about that later as well, but you're talking 18 member institutions, including Notre Dame, media companies, ESPN and Fox, legislatures could get involved. It's going to be very, very complicated, at least people behind the scenes pulling strings to see if this case can really settle, right? But big picture, what happens at a mediation is that the parties will come together with a third party who's an attorney who will try to facilitate that negotiation between the parties, try to get the case settled. He's called a mediator. What the parties' obligations, what FSU and ACC's obligations are at mediation is really simple. It's to show up, and the individuals who have to show up are counsel, the attorneys, and then a representative from each party who has authority to settle the case. You actually have to file a document with the court saying such and such individual will be at mediation and will have the authority to settle on behalf of that institution. Florida State will have that individual. The ACC will have that individual. The way mediations generally work is that you start out with the mediator giving both parties the ground rules, which is that everything in mediation is confidential, and that and the reason for that is to try to facilitate negotiation. So you don't want to have one party say something at mediation that could be held against them in court later. So there are strict rules on confidentiality, so you can speak freely to try to get the case settled. And then what the mediator is going to tell the parties is that he cannot force them to settle the case. He tries to facilitate a negotiation, and because the mediator has very limited powers, really just to be there to be a third party to try to facilitate the mediation. FSU and the ACC have a very low bar to pass to satisfy what Judge Cooper ordered with respect to mediation, which is show up and to, in good faith, negotiate, which under Florida law just means show up. There is no obligation whatsoever to ever even put an offer on the table. You can show up in good faith, hear what the other party has to say, and then leave. And so how you hear what the other party has to say in mediation is you have that general session that I alluded to earlier. Each party typically puts on a presentation to the other, explaining the strengths of their case and the weaknesses of the opposing party's case. Then you'll go into separate caucuses, and you'll negotiate amongst each other, and the mediator will go back and forth between the rooms trying to see if there's a settlement that can be facilitated. Again, and this is really important for your audience to understand, and Judge Cooper said this yesterday, really all you've got to do is show up. That's all you have to do. So after that general session, if the ACC says, pay us the full exit fee and we've got your rights for 10 years, and that's the deal we're willing to do, then the mediation can last 30 minutes. If, on the other hand, the parties really are ready to settle the case, you could have multi-day mediations. I've been in that many times before, where the parties are negotiating, going back and forth many times. And the mediator can be a very effective advocate for both sides to try to get it done. Just so your audience knows, I'm of the belief that the best mediators are the ones that are hardest on the parties in each individual room when the negotiation is going on. You don't want a message carrier. And the reason for that is because, they're being really hard in the other room too. And that's what allows each party to understand the weaknesses of their positions and then can facilitate a negotiation. But again, all of that is predicated upon the parties being willing to negotiate at this point in time. And it's pretty early on in the process, so we'll see. But as we said last time, and as I hope we get to talk more in the future, I think this is an exceedingly difficult case, particularly from the ACC's perspective, to settle, and involves many parties that the ACC would have to satisfy to settle. And that makes me worried that this is going to be protracted litigation.
So stay tuned, because what could happen next is a little bit to be determined. Leon County, we do not have a court date yet. We have roughly put a timeline on it of it could be mid to late May, given that 27-day filing window if each legal team uses the full. On the FSU side, 7 days. On the ACC side, 20 days. We'll see what transpires there. In Mecklenburg County, there is an appearance on May 2nd. Again, we don't have an agenda, so we really can't brief you on what's to come there. But again, we have two cases going. Of course, the Clemson case too in South Carolina. So lots to discuss down the road with Will Fixel. We'll bring you on another time and definitely get into the topic of mediation, because it's an interesting one, but complex because of the nature of this case, the amount of money involved, and also we do have a case in North Carolina too. There's a lot of moving pieces here. A man of many hats. Again, thanks to Will Fixel for joining us. Jerry Cutts, I'm Bob Ferranti. Stay tuned. We'll have a recruiting transfer portal related podcast coming up later in the week. Again, thanks for watching the Osceola's YouTube channel. Check out theosceola.com if you're not a subscriber. It's a good time to jump in. We're covering a lot of things still, even though spring football's out. And yes, we will bring Will Fixel back to talk this lawsuit, and a man of many hats. He'll talk some football too. So thanks.
Your Seminoles kick off the 2024 football season in Dublin, Ireland, as they face the Georgia Tech Yellow Jackets in the Aer Lingus College Football Classic. Join fellow Florida State fans on a trip you won't soon forget. Game tickets for the August 24th matchup are now available through Florida State Athletics Ticket Office and selling fast. Visit SeminolesToIreland.com. That's Seminoles, the number 2, Ireland.com. And go Noles!